Okay, I'll talk to you about a post somebody on Facebook shared. We are Facebook friends. He's a follower of legal reform. He contacted me, asked me a lot of questions. Every question he asked, he wound up with 2, 3, or more questions behind that. Anyways, I told him I posted about it. I posted this about it on legal reform. That, but I talked him through it, and eventually he just started going to my page legal reform. He told me if I could just tell him. I said, well, I do, because most of them are videos, and I not only show you where it's at on the internet, I read it to you. So he took a lot of stuff, and we talk, and the kid's brilliant. I shouldn't call him kid, he's a man. But he's working on getting his life back. You know, if you ever been in child custody things, CPS, Child Protective Service, anyways, I explained to him, he tried to explain to me his case. I told him there was no need to, because he needed to listen to me first, and that's when he started asking me all these questions about the law. So I really don't know about the particulars of the case. But I know there's one thing for sure. There's no lawyer or judge abides by the rules or the codes, and that's misconduct. And it's mandatory to report misconduct in the rules of professional conduct and the Code of Judicial Conduct. And he's telling them in court, and he's put it in complaints, and everybody's ignoring him, which is basically violating the oath and defying deprivation of rights. By depraved. So I was telling them that no matter what courtroom you go to, there's always a conspiracy against rights under the color of law. Criminal court, civil court, child court, custody, whatever. So now he's using a whole lot of stuff. And let's see if we can get some people down there with him as witnesses. You know, he's working on getting his kids back. They broke every law possible just to take his kids. But actually it started his ex, and she had connections, and she worked for the court or something like that. But anyways, he knew something was amiss, nothing was right. And so I just showed him where to look, how to look. And he efficiently proved and cited a conspiracy against rights under the color of law. He cited violations of rules of professional conduct and the Code of Judicial Conduct, as reporting misconduct is mandatory in both and no action taken. John is brilliant and insightful, inspirational to be sure.
The orders. Not only did I get it from Rich and Roll. The orders. Not only did I get it from Rich and Rosemont, not only did I get it in Skokie, not only did I go out to Maywood, I came into here and got your chief deputy clerk to say it. So you go ahead and you try to burden me and punish me and violate more of my civil liberties, and I'm going to tell you, this is going to be bad, really bad. I've done nothing wrong. She's lying. Candor to the tribunal. She's not even listening to her own words. She's lying. My own attorney filed out the June. Tell me this. Open up the case right now. Let's have it out. Okay? Look at June 11th orders that you filed. The June 11th orders show that you reinstated the order of protection. Why did you sign them again non-proton on the 24th? It's pretty clear. But again, you state in the record, if you look at the case summary, that you signed non-proton for the November orders. But you know what? Or October 13th. But you didn't. Because you look at your October 13th orders, they're not signed non-proton, but you did sign them on the 19th. I know this record in and out. I know every mistake you guys have made arrogantly, and I'm going to expose it all. Take anything away from me you want. You already have what's most important to me. I'm not going to sit here on the hospital bed and die on about it. And let's bring up the due process of child support that I won't submit to. On May 30th, when I told you didn't have orders for your guardian ad litem, what did you do? You replaced the interference or suspend my parenting time, June 24th date, with child support. You gave me 15 days to reply when in court you gave me 21. You're all over the place. You're all over the place. And you're going to tell me I'm lying about that? Please, go ahead. I have court witnesses all the time. I have affidavits lined up. Go ahead. Throw your book at me. Do it. Do more. Show your impartiality. I'm the plaintiff.
Your Honor, if I may address the court.
Yes.
There were occasions that Mr. McHugh is referring to with respect to court orders, but we sent the court orders to Mr. McHugh. He did not reply, and so...
Well, no, you didn't. Where did you send them? I'm not going to listen to any more of her lies.
I choice. She has the floor.
Go for it, then.
Thank you.
So, but Mr. McHugh doesn't respond to the emails seeking approval on the court orders that were drafted. I do also want to note
Lying again.
that while we were here, before the judge took, or Your Honor took the bench, Mr. McHugh called me a scumbag twice.
And dog water. Well, you're dog water.
You're going to stop being disrespectful, Mr. McHugh, or we can stop this right now.
Stop it. Stop it. You want to interfere on my civil liberties, I'm letting you know that any attempt to detain me is a threat on my life, and I will defend it. I'm not afraid of anything now. Yeah, what do you want to do? I'm okay.
Sit down.
I'm okay. I'm okay. I'm not a dog.
Sit down.
I'm not a dog.
You're interrupting people.
Go ahead. She's lying to you. And you have a duty to report anything unethical. It's in your canons.
Continue.
Those are the only remaining today.
And I told you, reporting misconduct, his lawyer, the opposing party, both violated the rules of professional conduct. And it's mandatory to report that misconduct by judges and lawyers. Anybody having any knowledge of any misconduct is required to report that misconduct. The rules of professional conduct and the Code of Judicial Conduct are the legal obligations of all lawyers and judges in a court of law, not just to him or to you, but to the public in general. And what did the judge do? Nothing. Violating the rules and the codes, that's called for disbarment, removal from the bench. The penalties are fines, removal from public service, and incarceration. They're working together, thus proving a conspiracy. They conspired together to deprive him of his constitutional right to due process. Effective assistance to counsel. And effective assistance to counsel described in the rules and the codes. But it happens all the time, no matter what court you're in. That's the point I'm making. And here they are, for you to see. If you read the rules and the codes, you'll see that they broke every law possible. Violating the rules and the codes is intentional. It's always intentional, wantingly and willingly. He lost his house, not custody of his child, but the other side, she's being a little vindictive because he's fighting back, so she's withholding visitations, and that's what, he dealt with everything until they denied him visitations, and eventually he got a hold of me, and I explained to him the conspiracy against rights under the color of law, and that's what he's exposing right here, right now. Let's listen.
I don't have the full electronic file in front of me. I'm unable to open it when I'm on Zoom because it becomes part of the screen. The history of the use of non-proton is sometimes done. The clerk doesn't get the order and it needs to be put back into the system. It's not a hearing outside of the jurisdiction of anybody.
It also comes with...
At times, when I'm on trial, I don't get all the orders through. So I'm entitled to set it back to the date that it's supposed to be effective. because the use of Zoom and computers crashing and systems crashing sometimes cause us not to have direct train entry of orders. So we do our best to get them entered in a timely fashion with Stu. But there was no hearing other than an emergency order of protection that was done outside of your purview. They had the right to bring an emergency order of protection ex parte. The statute provides for that.
Man.
Yes.
Okay, number one, the procedural device also comes with the insurance of the ability to contest it and have a hearing to contest the orders. Now, if you're stating that you sometimes don't sign the orders at the right time, May 22nd all the way until June 11th is how many days? That's way more than the allowances of that. I didn't get due notice of the non-prompt use or the insurance that it provides me to be able to appeal that order. And the fact that she missed the order, let's just forget about that. Let's explain some procedural mishap that happened because of technology, and we'll hang on the last words somebody said. The order of protection expired. There's no way of reinstating it unless you went from June 11th, where I have your signature certified, to June 24th, where I have your signature, and your signature has non-promptunk on it. How do you explain that you had to rewrite orders non-promptunk within how many days? 10 days between? It doesn't make any freaking sense. The non-promptunk should have been from May 22nd when she failed to file the orders. However, you signed them on June 11th, and then you did non-promptunk on the 24th. Bring up the case summary if you can't bring it up. Have Terry bring it up. She's standing right here. I'm insisting.
Not here.
Well, whoever is in the stead, I don't care. You can easily look this up. It's on the case summary, which I have 3 copies certified, filed in 2 different counties, because I'm making sure I'm building my defense.
Judge, are you going to cooperate with Mr. Lodemeyer?
You can't manage the guardian ad litem, the one you had. Your impartiality showing that you were impartial to the GAL by not enforcing your orders for her to meet with me, by accepting this so-called attorney's motion to suspend my parenting time that was met immediately after the guardian ad litem refused to meet with me and pulled the swap. It's all there in my affidavit. They're not plebeians.
There's
Just did a motion, and then she put the hearing right before. I never stated that. You accepted. What I stated was you accepted her motion to suspend my parenting time. It's been a year now, so it doesn't even exist. So, I mean, we can back talk and we can do all these types of things.
See, what's going on here is they're upset because he didn't take what's called the gift, what they offered him in the first place. It happens in every court. They throw out a hoop, you jump through it, and no matter how well you maneuver through it and get through it, they'll exceedingly put out more and more. It's just meant to keep you entwined in the court system. But if you know the rules of the codes, that's actually breaking the law. And he's reviewing every law they're breaking, and they will constantly do it and come up with constant excuses. But there's no excuse for the privation of rights. There's no excuse for a conspiracy to privation of rights under the color of law. Okay, legally, everybody in that courtroom is supposed to go to jail. Any lawyer, judge having knowledge of what's going on in their right, in this courtroom, they're supposed to report each other. Everybody's supposed to report each other and themselves as well, according to the rules and the codes. And he just almost got them memorized. We talked about him a few times.
Participate and speak with Mr. Lodemeyer about.
You cannot manage the guardian ad litem. I objected to his presence in this case because you cannot manage the guardian ad litem. You can't. There's no cause for her. You're going to bring an 1890 Paris Pantry law that states that the courts can enter in on behalf of the citizen. There's no cause. The cause was not found. There's no cause. And to bring to your attention, all the correspondences in which I filed in multiple cases to meet the rules of evidence in other counties, so I can submit them to your county, with them certified from them shows that she states by oral motion, I requested a guardian ad litem. I haven't learned Latin since meeting you, since being in this court. These emails state, tell her. These emails state that I requested a guardian ad litem. I have no idea what it is. And if you can open up, it's not Terry, but we can stand in. If you open up your own guardian ad litem, the purported one, Angel, you'll see that she has no orders in her case. Not only why? Because the orders were not filed? Like I have stated several times, she has a PDF edited version as her exhibit showing that Michelle ordered it. This isn't going to be heard in this case. I'm explaining you how much of collusion and conspiracy on my civil rights has taken place that I don't expect this court to admit to it. I'm taking it somewhere else. I'm requesting again a hearing to vacate the agreed injunction that was obtained through fraud on March 18th. There was nothing on your docket for a hearing on an order of protection, whether we argue non-pronged, whether it expired, whether it didn't. You never gave me a hearing. To date, I've never had a hearing. I've been silenced by every attorney, and I won't be silenced anymore. I have all the evidence and all the proof.
I recall that you were represented by Marcus Dominguez on the order of protection.
Your Honor, we have no notice of any other proceedings in any other counties. I have no filings from any other county.
And you won't.
In terms of his allegations that somehow I've exercised less than full candor to the court, expressly denied him, taking pride in my honesty.
Considering an emergency order of protection, so ostensibly, Mr. McHugh can move back into his home when the GAL is afraid to have her in his own office. She said they had to lock the doors when he was coming to the house. We shouldn't be.
Judge, with respect to the remaining things that Mr. McHugh has said, I just want to encourage the court that I think that these are intimidation tactics that are at the very heart of what my client and I have attempted to maintain to the court, which is Mr. McHugh presents safety risks to my client and potentially others in this case. His displayed paranoia appears to continue unabated. With respect to his arguments, whether they sound in 1301, 1401, or some sort of appeal, I think most of those, the ability to file these motions is told. He hasn't filed anything with respect to them, and so I just ask that if Mr. McHugh is going to continue to make arguments, that he have pleadings on file with respect to them before we are obligated to respond to them.
Ms. McHugh, you do need to put whatever this motion is that you're asking to vacate into written form, give counsel time to respond, and then we'll be happy to get a hearing.
I have several things ready to be filed for this case. I would also request to swear her in and ask her if she failed to file the May 22nd court orders and the orders for the GAL. She states that she has candor towards the tribunal. She's had nothing but professional. Take an oath. Have her take an oath right now before this court and swear to it.
That's not how the process works in this court.
Okay, right. So everyone else is supposedly.
What is it that you think that she didn't file? Because I know. So
I know.
Explain to me what it is that you think.
The May 22nd status call where you selected Angel Tribe, where you set a date to June 11th, because my attorneys were allegedly going on vacation. She did not file the court orders from that hearing, that date. So the GAL orders never got written, and the order of protection, the interim disposition order never got signed, and they never got submitted to the court. And I have evidence of that and affidavits, and that's why I'm asking you, please put her license on the line. Have her swear to the court. I raise my hand that this is true. I swear under perjury, under God, everything good in the world. My fingers are not crossed. This is the honest to God truth. I've seen it with my own eyes and your own records. She did not file the orders. She has violated her oath. She has completely deprived me of any type of due process, colluding with my attorneys. And I have evidence every step of it along the way. Every step. Put me in jail.
Your Honor,
I could fight it from there. It's that simple and clear.
Your Honor, I just want to clear Mr. McHugh was represented by counsel, very capable counsel, and Ms. Cooper and Ms. Melnick at the time. He also had another appearance on file specifically for an order of protection attorney. So that, I don't recall the gentleman's name, but he had 2 firms engaged at the time of May 22nd. If he is in fact alleging that somehow I was failing in some capacity, he had capable counsel at the time in May to be able to point out any defects. None were raised. In addition, Your Honor, I feel it necessary to point out to the court that attorneys don't file orders. There's no filing of orders. We email them to the court. They're emailed to the court and then entered by the court. I've never filed an order in my life because that's not what we do. And so it's peculiar that Mr. McHugh is now turned his aim toward me. But I suppose it's his right to do so here in this in this court of law. But it's concerning.
Okay, so may I have raised it. It's in an affidavit stating that she asked on October 13th, when you signed the orders for the jail to meet with me, to give a little chit chat to Irina, my capable attorney. I asked my attorney, which is in the affidavit, which states, what did the opposing counsel want to have a chit chat? Oh, she wanted to know what was in the orders. Look at your October 13th orders. There's 2 lines. When the next court date is, and the GAL should meet with me. She had a little chit chat with my attorney, and she's changing the words that Mr. McHugh had competent representation when my attorney did not engage the GAL when she knew about the conflict with their office. Even after you heard me explain the conflict and what this little court routine of let's hang on the last word of everything someone says, he's never raised these allegations, he's never done that, she's still not stated to the court on the record, did you miss the May 22nd court orders? Don't twist the words to say I didn't file orders. We all know the process, especially me. And your other lies about me not responding to orders to approve them are also lies. You will sit here and lie to the court, have no candor towards the tribunal, and you'll still perpetrate lies. The facts are the facts. She didn't file the May 22nd order. Your order of protection expired. The interim disposition expired. On June 11th, you signed the orders to instate the interim disposition order. Then you sign them again without even being able to tell me the procedural reason why you use non-prompton between 10 days, not since May 22nd. It's elementary. I can't believe I'm arguing this, and we're hanging on things on whether she files the orders or submits the orders to you, which she never did.
Your Honor, I want to make the record clear that I have a hard stop at 11 a.m. for a conference that I have.
So you're going to make certain you don't answer the charges, that you failed to order or provide the orders to the court on May 22nd.
Can I get some clarity so we can clean the record up a little bit? So is it my understanding, correct or not, that the motion to suspend and modify parenting time was from October 30th of 2023? Does that sound about right? That is. Did everybody agree to that? I just want to know, yes or no, I just want to know.
Tell me the date one more time. I want to be
October 30th of 2023. Right, okay. There's a resulting order. Is it that suspended parenting time? Is that accurate? Do we have that?
No, there's none. They sat on it.
Late file.
So I was thinking we just have it, if the court would just set a hearing date on the motion to suspend.
Well, that was the purpose of having a GAL, so that everybody's position would be made known and so that you would be able to advise the court as a guardian advisor does on behalf of the minor children.
And if he doesn't, and we can have the hearing, and then it's for the record, and then if he's participated between now and then, he has. If he hasn't, then so be it. And that would be my suggestion.
I'm veteran.
Very well. So I'll be back in just a second. That's trying to bump the case over to set a hearing.
Yeah, he's really good at what he does. John, he's not a lawyer, but, you know, I really appreciate that the fact that he contacted me because he's a dad. And a dad's love put him on a path seek knowledge of a legal learned professional. And he finally understood. It took him a little bit to understand that that's what judges and lawyers will hold you to. The knowledge of a legal learned professional. And how is that a fair trial? And he described it. You heard him say it. Privation of rights under the color of law. A conspiracy against rights under the color of law. And nobody argued that because they can't. Now look it up. Penalties for a conspiracy to deprive rights under the color of law. You know. But I really love this guy. He wanted to know. I told him, gave him all the literature. He read it. You know, I only showed him the path. He didn't just talk the talk, he walked the walk. He went there. See the confidence he had because he knows what he knows. Nobody can ever take that from him. He said, they want to lock me up. Go ahead, I can do it from there. You know, because it's once you read a lot of this stuff that I post about, you don't forget. It's hard to forget. When you know, you know. All right, nothing but love for you. All right. You know, this is for John James, John Q. Public, Jane Q. Public, Average Joe, Average Joanne. You really got to learn what your constitutional rights are, all right? It's got to start with effective assistance of counsel. I'm going to go over the rules and the codes and explain explicitly what he's been telling them. Okay? Nothing but love for you, all right? May your Creator always be with you. Peace out. But, that kid's brilliant. By the time he hits my age, you know, I'm very proud to meet him. Very privileged to have met him. People look him up, you know, help him out, you know, follow him, listen to his videos. Very smart man, inspirational.